Welcome to Week 5's recorded lecture, continuing character evidence. This will be our last week covering character evidence. The cases we'll discuss today are in your casebook, pages 157 to 171. The first case we covered was Gagne v. Booker. This is a United States Court of Appeals case for the Sixth Circuit from 2012. The defendants in this case were accused of raping the victim. The defendants contended at trial that the victim had engaged in consensual group sex with them. The defendants lost at trial and were sentenced to over 20 years in prison. One of the defendants, after losing on appeal, was granted habeas corpus from a federal court. The defendant argued that his defense of consent would not be believable if the jury didn't hear about the victim's prior similar behavior of group sex, saying that group sex was bizarre enough that the jury would not believe this instance was consensual unless they knew the victim had engaged in prior consensual group sex with the defendant. At issue here is whether evidence of that prior sexual conduct should have been admitted at trial, and whether excluding that evidence amounted to a violation of the defendant's right to a fair trial and right to present a full defense. This court reversed and denied the habeas petition. They held that the Michigan courts had consistently rejected similar arguments to this in the past. It was a split decision. A concurring judge felt that the evidence of that prior sexual conduct was classic propensity evidence and was properly barred. The jury had already heard evidence of the victim's willingness to have sex with the defendant because evidence of their relationship had been admitted and evidence of another sexual encounter had been admitted. In a dissent, one dissenting judge emphasized how bizarre the conduct would appear to the jury if they heard that the victim had engaged in virtually identical conduct on another recent occasion, and then felt that that evidence should have been admitted. Another dissenting judge felt that a rape defendant should be allowed to introduce evidence of past relevant behavior, going to whether the sexual act in question was consensual. If this dissenting judge's opinion had been the holding, taken broadly, this would essentially eliminate rape shield laws. The next case we covered in Johnson v. Elk Lake School District. This is the United States Court of Appeals for the Third Circuit from 2002. In this case, the plaintiff claims she was sexually abused by her guidance counselor when she was in high school. The plaintiff is appealing from an adverse jury verdict, claiming an error in the trial judge's decision to exclude evidence of another crime by the guidance counselor. That other crime was the counselor touching one of his teacher's assistants without her consent. At issue in this case is whether the touching involved in the prior incident was intentional and therefore admissible in the current case under FRE 415. This court disagreed and ruled that it was within the trial judge's discretion to exclude the evidence of that prior incident. So, question, FRE 415 states that the evidence falling within its scope is admissible. Does this mean that the evidence is completely admissible without the usual balancing test of prejudice versus probative value? And the court in this case held that no, FRE 403 balancing test still applies even when evidence is potentially being admitted under FRE 415. Rule 415 states that evidence falling within its scope, this is a duplicate side. So the next question is, why did this court uphold the trial court's decision to exclude the evidence of that prior incident with the guidance counselor? This court stressed the insufficient evidence that the guidance counselor's prior incident was intentional, which would be necessary for it to qualify as an offense of sexual assault under FRE 413. So that evidence of intent was very important. This court also noted the differences between the two incidents and the crime in question, and then also the isolated nature of that prior conduct. And that is all the cases that we covered this week. Next week, we will move on to policy exclusions, which is other evidence that might be excluded from trials for different policy reasons.